Bismillahirrahmanirrahim. Good morning, everyone, and welcome to our presentation on the new companies law. Thank you for taking the time this morning. I'd like to, first of all, start off with a brief introduction of the presenters today. My name is Rafiq Jaffer. I'm a partner in the banking and finance department of the firm. I head our KSA banking practice and the firm's debt capital markets practice. My partner, Chris Webb, is a partner in our corporate commercial team. He is based in our Riyadh office. Omar AlHumaid is also based in our Riyadh office and is a senior counsel in our corporate structuring team. And we've got Amreen Bidiwala, who is a senior associate in our banking and finance team. So just going to the next slide, Marva. So we'll be covering the new companies law today, and I think this is, this is in a series of major laws that have been coming out over the past few years. So back in 2018, we had the bankruptcy law, which came in, and I think substantially revised the bankruptcy liquidation regime and has had significant commercial implications on the market. We had the movable asset security law that came in 2018 and then was revised substantially in 2020. So that law has had a major impact on the banking and finance space and on financing generally. And I think and then there are other laws that have come in, amendments to evidence law, which has brought in, digital signatures, etc. The electronic transactions law. So the new companies law, I think, is in a series of significant changes that has come in the legal regime in KSA. What we'll be discussing initially, we'll go through a quick introduction and overview of the new law. Then we'll focus on certain areas, starting with the debt capital markets area and on the financing side. We will then move to the equity raising options and some corporate structuring considerations, which are quite significant. We'll then move on to the types of companies and the changes that have come in there. Significantly, the introduction of the new simple joint stock company, which brings a lot of flexibility. We'll talk about shareholders agreements and family charters, and we'll also then talk about changes to directors' obligations. So with that, I will hand over to my colleague Omar to give us a high-level introduction on the changes that have come in. So Omar, over to you, and can we move to the next slide, please?
Well, thank you, Rafiq, for the introduction, and thank you, everyone, for joining us this morning for the new companies law session. We are happy to have you all and go through the recent changes in the new companies law. So as you may know, the new companies law have been approved by the Council of Ministers of Saudi Arabia back in the summer, around end of June this year. The draft was circled for public opinion for a few years, and now will be enacted and come into force towards the end of this year or beginning, in fact, in January, early next year. The law was published in July, and typically 180 days from the publication where the law becomes effective. So we do expect the law and implementing regulation to come at the beginning of the 2023. So the new law is an interesting part about the new companies law. It is one piece of legislation that's meant to govern all the commercial and non-profit and professional companies in one piece of legislation. With that in mind, the current law, companies law, and the current professional law will be superseded along with any other professions that conflict with the current companies law. The law came out with 280 articles, and it refers a lot to implementing regulation in different parts to give guidance and clarification. The implementing regulation, as mentioned earlier, should be coming by the new year, with further clarification on certain parts, and particularly on technology, notification and invitation between parties and shareholders meeting. There is 2 years grace period to comply in the new law. If you can go to the next slide, please. So what the new law is came up with a few interesting points, which we summarized in this slide and the next. Mainly is the introduction of the family charters and the introduction of shareholders agreement. The family charters meant to give guidance on how to distribute dividends between family members, and it should shed light on governance issues and succession plan. Also, the charter should give clarity on how transformation happens between from the first and the second and third generations. Also, the shareholders agreement shareholders agreement and family charters will become binding part of the constitutional document, with the fact that it's not contradicting the constitutional documents and the laws and approved by the ministry. We will come into that in a later slide. The second point that we saw is as interesting in the new companies law is the variation of the dividends distribution in the new law. The dividends can be now distributed annually or an interim basis for the limited liability company and simplified joint stock company. This should assist to develop dividend distribution in these companies. Again, the regulation will shed more light on how this will be implemented and what is required to apply the distribution of dividends. Another third interesting point is the introduction of alternative dispute mechanism for shareholders dispute and between companies and their shareholders. In other words, arbitration now can be agreed on between the shareholders in the relevant articles and the bylaws of the companies. We'll touch base on that in another slide. A fourth point is the introduction of the simple joint stock company. As Rafiq mentioned earlier, this is meant for flexibility and mainly that came to meet the high demand for such need in the venture capital transaction. There will be another slide talking about the key features of the simplified joint stock company. The fifth point is the introduction of debt instrument for LLCs, which is again a huge shift in LLCs, and that will be also discussed in another slide down the line. Shareholders agreement in LLCs now have moved from being the law required them to be the meetings will need to be convened within 4 months, but however, the new law refers to 6 months, which increased the time frame for such meetings. It is also flexibility on trading names. In the past, there were some practical issues when it comes to name reservation for companies, but now the law clearly refers to names not in Arabic language can be approved, but with the condition that shouldn't contradict any trading name laws. Last point, which or just before last, it's the introduction of electronic resolutions for the limited liability company and joint stock companies and simplified joint stock companies. That has always been the case, particularly after the pandemic, but now the law has made it crystal clear how this will be, how this can be important part of the notification between parties and passing resolution in electronic means. The last point, which we see as key changes, and again that came to support entrepreneurs and Saudi startups, is the exemption for small companies and micro companies from the requirement to appoint an auditors. This is a statutory requirement, but for small and micro companies there is an exemption for the first few years, and this meant to support entrepreneurs and startup. The law doesn't explain or define what constitute or what can be classified as micro or small, and the regulation is going to clarify that. But however, in practice, and other authorities have interpreted small companies as a company with between 6 to 48 employees with annual turnover any amount between 3 million to 40 million. That is a small company, whereas a micro company with up to 5 employees with a total revenue of not less than 3 million. The exemption is applicable, must be stated in the articles, and must be approved prior to the incorporation of the companies. It is also important to say the exemption is not available for foreign company, regardless of the size of the companies, whether it's a small or micro. Also, the exemption from this requirement is not available for publicly traded company. If you can go to the next slide, please. Like with the current law, there's 5 different types of companies, with the clear introduction of the simple joint stock company and the removal of the partnership, which is the muhasa company, from the current regulation. The new law, particularly in the first chapter in Article 4, refers to the types of entity that can be used as legal forms for newly incorporated companies: general partnership and limited partnership, joint stock company and simple joint stock company, and LLC or limited liability company, which is the most common type of entity. It is in the past there was a joint venture which has been removed and has been replaced with 2 types of partnership, which is in particular the general partnership and limited partnership. With the type of companies, I'll refer now to my colleague Rafiq to go through the financial consideration in the next slide.
Thanks, Omar. Can we move to the next slide, please? So I think the new law has brought in a lot of innovation in the area of financing, especially in the area of sukuk and bond financing. The first point was that in the old law, there was a restriction on conventional bond offerings. So the law said that you had to observe Sharia rules when you were or Sharia principles when you were doing an offering to the public. That has been replaced with Article 117, where it allows for conventional bond issuances and sukuk issuances. So that's I think that's quite a significant change from the joint stock company perspective. For limited liability companies, under the old law, it was not permitted to raise debt through public issuances or through bond or sukuk issuances. You could not do that for an LLC. Now, under the new law, there's a clear reference to conventional bond and sukuk issuances that can be made by LLC companies under the CMA law. So those two, and I think that for the LLC space, it really opens up a new avenue for raising debt. So, beyond the typical banks and other opportunities, this will be a new avenue to raise debt. The third entity, obviously the simple joint stock company, you can again raise conventional bond and sukuk issuances as long as the articles specify that. So I think in the bond and sukuk space, this is quite a huge step forward. Moving to the next slide. And again, because of the flexibility that the simple joint stock company gives you, it's not just debt instruments that can be issued. You can actually come up with hybrid issuances. You can come up with instruments that have sort of debt as well as equity linked features. You could possibly use the simple joint stock company for asset backed issuances. And I think a whole range of opportunities opens up through the simple joint stock company. There's also the ability to do convertible debt instruments. So obviously for joint stock companies and for simple joint stock companies, you can do convertible debt instruments. That would not be allowed for LLCs, but for joint stock companies, this would be possible. There's obviously the issue of preemption rights, the rights of the existing shareholders to subscribe in the event of a conversion. So this can be dealt with an extraordinary general meeting right at the outset when you're doing the issuance. You can cover off the point relating to preemption rights and get a waiver of preemption rights. Now, and while this is not in the new companies law, I thought it would make sense to refer to this here, where the Capital Markets Authority has issued regulations relating to special purpose vehicles, where it says that special purpose entities can be used for the purposes of issuance of debt-based recourse debt instruments, asset-linked recourse debt instruments, and asset-backed debt instruments. So I think this works quite well with the law, and it gives you this option to basically have a vehicle that would be specialized for the purposes of issuance of these asset-backed or asset-based instruments. The Capital Markets Authority has recently, as September 22, issued regulations which relates to registration of debt instruments offered by way of private placement for the purposes of direct listing on the Tadawul. And I think generally when you look at bond structures and sukuk structures, you see them listed on an exchange, in Luxembourg or in London or in Ireland to create that liquidity. But now, even if you're doing it on a private placement basis, you could actually do a listing on the Tadawul to give you that ability to give you that ability to create liquidity on the market for even these privately placed instruments. Going to the next slide. So moving on from the debt finance perspective and looking at more conventional sort of financing issues that were that came up from the last companies law. So under the previous companies law, it was not possible to create a pledge, or at least there was no provision that allowed for creation of a pledge of shares of an LLC. Now under the new law, there's an express provision for allowing the creation of pledge over LLC shares. Now, I think it's going to be important to sort of see how this all works, because pledges over LLC shares was being done, but it was being done under the movable asset security law, which treated the shares of an LLC like a kind of a right. And it was registered on the unified register. So now we'll have to see what happens with the new, if there are any implementing regulations that come out, or whether you would continue to register it on the URMA, or would you register the pledge on the Ministry of Commerce system. So I think these are things that we'd have to watch out for. But I think it's a big move forward to have certainty in the area of creating shares over an LLC. For joint stock company, under the previous law, obviously there were regulations in place for creating pledge over shares. Here, the new law again gives more certainty. It allows for express provision. It's basically, there's an express provision permitting share pledges, and which includes the dividends. So even the dividends would be pledged as a result of creating the pledge over the shares. And then there are some restrictions where the pledgee cannot attend AGM and vote. And some of the things that would be covered under a typical share pledge agreement are now covered in the law itself. Moving to upstream guarantees. Can we move to the next slide? So there was this issue under the old law, which stated that you could not make a distribution to your shareholders unless it was by way of a declared dividend, and that created an issue for banks, especially because you always wanted the parent company to guarantee the obligations of its subsidiary. And because of this restriction, it was problematic. So while Article 22 has similar provision where it says that any distribution could be viewed as an interim profit distribution, and distributions should only be permitted from distributable profits. There is an exception in Article 72 where it says the competent authority can determine cases and controls under which the company may not provide a loan-related security to any of its shareholders. So hopefully, now this is something that's not been cleared up through the law, but I think it opens the door for this issue to be cleared up through regulation. So again, this is something that I think that would give a lot of comfort to the banks if they're able to take upstream guarantees, but it's still a question mark, and we hope it gets cleared up soon. So I think those were issues around upstream guarantees, debt capital markets, and security over shares. I'll pass on. Can we go to the next slide? And I'll pass on to my partner, Chris Webb, to take you through the equity raising options and other equity related points. Thank you.
Thank you, Rafiq. The new law does bring in a number of new features, new innovations in relation to the capital structure of companies. Firstly, the new law introduces a distinction between authorised capital and paid up capital. So a company can have an authorised capital, but with the paid up capital being somewhat less, and the paid up capital can be increased over time later on within the limits of the authorised capital. So, for example, in the joint stock company, there's a capitalization of 500,000 a minimum, but paid up only has to be a quarter of that, and paid up can be paid within 5 years. The new law also provides for different issuance of different types of shares: ordinary shares, preferred shares, redeemable shares. There's not a lot of detail around these. We expect that the detail will be provided in the regulations. The company can confer certain types of rights and restrictions upon different classes of shares. However, the law does say that shares of the same type and class will have the same rights and restrictions, and these should be set out in the articles of the company. It will be possible to convert one class of shares to another class of shares through an extraordinary general meeting if the articles so provide. Unless, of course, the issuing decision or the resolution or the decision that issues the class of shares provides for automatic conversion on the occurrence of certain specified conditions. Another restriction that's set out in the law is that ordinary shares and preference shares cannot be converted to redeemable shares without a unanimity of the shareholders. And there's also a provision for a special general assembly for any conversion that constitutes a variation of rights, for example, in relation to priority. That would operate in addition to the extraordinary general meeting, and the participants in the special general assembly would be the affected class of shareholders. The new law does contain provisions permitting share buybacks if the articles so permit. There's also provisions around rights issues, and these provisions do state that rights issues can be suspended in relation to existing shareholders, and could also be opened up to participation by persons who are not existing shareholders. There's also express provision for the sale or assignment of rights, right to participate in the rights issue. Next slide, please. So to summarise in relation to the types of shares that are set out in the new companies law, joint stock company, now has a distinction between authorised and paid up capital, provides for different classes of shares, ordinary preference and redeemable. Treasury shares are expressly permitted. These shares don't have the right to vote, and there is express provision for changes of classes and types of shares. In relation to the simple joint stock company, which is a new feature of the new law, there is similarly a distinction between authorised and paid up capital, and there's express provision for multiple classes of shares. So we think that this will be very useful, for example, in structuring venture capital transactions where it's been problematic to have the sort of different classes of shares that you usually see in that sector. So we think the simple joint stock company will be very useful in that sector. Limited liability companies still have a single category of capital among partners. That's the same as the old law, but there is a provision for treasury shares for limited liability companies. Next slide, please. Next slide, please. So there's a number of structuring features under the new law. One new feature is the provision for corporate splits. A company may be split into two or more companies, even if under liquidation. So this could be significant, for example, in a situation of a failing bank, and perhaps the split could be used to create a good bank and a bad bank that would help with resolution of the bank's solvency issues. There is a principle of universal succession. So as a result of the split, all assets and liabilities are automatically assumed by the surviving entities. Although if the creditors consent, they can be assumed by one of the entities. There's now provision for drag along and tag along rights. This is something that was always a subject of a lot of uncertainty under the old law. So the company's articles can now include an express provision to compel minority shareholders to accept an offer from a buyer at the same price and the same terms, purchasing the majority shareholders' shares. And similarly, the articles can provide for minority shareholders to compel the majority to sell their shares at the same price and on the same conditions. There is a provision for mandatory offer. So, and this affects joint stock companies, both the standard joint stock company and the simple joint stock company. So a majority shareholder that has 90% of the shares is under an obligation to actually disclose its position, and the minority shareholders can then compel the majority shareholder to make an offer to buy them out. Further detail will be added in the regulations, which haven't been issued yet. But this is a useful innovation that would allow exit by minority with a greater deal of certainty. Conversely, there's squeeze out provisions also applicable to joint stock companies and simple joint stock companies. A shareholder with 90% or more of the shares can request the competent authority to squeeze out the minority shareholders. Next slide, please. Reserves in relation to joint stock companies. The Articles of Association may provide for a certain percentage of net profits going towards reserves, but this is not mandatory. And the General Assembly can also decide what to do with the reserves that have been accumulated. These can be distributed to the company or to the shareholders. So reserves are not mandatory in the joint stock companies, and similarly, they're not mandatory in relation to LLCs. When it comes to capitalizing companies, there is, as there has been under the old law, a provision for capitalization in kind as opposed to cash capitalization. The new law contains a fair bit more detail as to how this will happen in relation to joint stock companies. You would need a fair value report, a report prepared by a qualified auditor. However, this is not required for a simple joint stock company, except where the value of the assets in kind exceeds 50% of the capital. There's also express provision in the new law for sweat equity or contribution of services as a contribution to the capitalization of the company, and that was not at all clear under the old law. With that, I'd hand back over to my colleague Omar, who'll speak further about the corporate structuring implications of the new law. Next slide, please.
Thank you, Chris. Thank you very much. Oh, well, as discussed earlier, the new type, which came as an innovation in the new companies law, is the introduction of the simple joint stock company. The new law introduced it, and the objective is to meet, as discussed earlier, the high demand and needs and growth in the venture capital market in Saudi Arabia. Historically and currently, Saudi startups and co-founders would use international and overseas structures to get their startups funded in Saudi. The regulators in Saudi are well aware of these structures, and they came with the symbol joint stock company to basically capture the transactions locally and regulate such important area. The joint stock company or the simplified joint stock company can be fined or established by one shareholder. There is no minimum share capital requirement, which is unlike the joint stock company, where there is a minimum share capital requirement. Key features for the simple joint stock company is the issuance of separate classes of shares, as discussed earlier. The shares would have different rights and obligations. And again, this is very interesting and important for venture capital companies. The company can be managed by a single manager or two managers or a board of directors. The article and bylaws would normally refer or list the appointment process and dismissal of the directors, their authorities, and their limitation and powers. Of course, like any other types of company, the chairman can delegate some of his authority to someone else to represent them in the ground. From the name, simplified joint stock company is meant simplified way of doing business. With that, the general assemblies, whether it's ordinary or extraordinary, will be replaced by a similar shareholder meeting in the company premises, or can be even virtually. So there isn't a requirement for EGM or OGM. The shareholder can regulate the structure through the bylaws and the articles and agree on the certain terms they want to have in their company, whether it's preferred shares or alternative dispute resolution like arbitration, which is another interesting point to be an option for the shareholders. There is also a restricted period. It shouldn't be more than 10 years. Where one shareholder will be restricted from selling their shares, of course, with approval of company shareholders. And that's sometimes can be used for co-founders of startups. Next slide, please. So here is the joint stock company. With the new law, there has been some changes. notably the share capital requirement. In the past, it is 5 million Saudi riyals. Now there isn't, the minimum share capital has been decreased significantly to 500,000 Saudi riyals. There is also, as Chris mentioned earlier, there is an authorized share capital and actual share capital. In case of a share subscription or increase of capital, all the authorized share capital must be subscribed. And the regulation or the bylaws and constitutional documents would normally specify the mechanism of that. The second point, which is another key changes for those who are interested in the capital market, is the lockup period. The current law lock the co-founders for 2 years. They can't basically exit and leave without during the time of going public. So the new law no longer requires the lockup period for newly incorporated joint stock companies, or even during the conversion. And this should over shares through the IPO in different stages during the incorporation process. But the law is clear. This has to be in line with the approval of the Ministry of Commerce and Capital Market Authority. This should allow companies to come to the market more quickly, particularly younger companies and startup companies. Another point for joint stock companies is there's no more requirement for shareholders resolution to the ministerial resolution to incorporate companies. Now it is more simplified process, unlike the current law where a ministerial resolution has to be issued prior to the incorporation of the company. Third point is the remuneration cap for directors. The current regulation or the current companies law put 500,000 as a maximum remuneration for directors, whereas the new law, again, with the current law, there has been some exemption. For example, for Aramco, there was a royal decree giving them flexibility to remunerate their directors in different mechanisms. But the new law comes with introducing different options of remuneration, which can be listed in the bylaws and the articles. Those include attending meeting allowances and benefit in kind and net profit quota, or combination of any of the two benefits. The implementing regulation will set out the measures on how to apply these changes. The fourth point, as Chris mentioned earlier, classes of shares. There's different classes of shares for a joint stock company, which increase the flexibility in capital arrangements to access larger pool of capital. Also, the drag along and tag along rights, which has also been an interesting part of the joint stock company. So next slide, please. So with the limited liability companies, now it is the most popular type of vehicle that shareholders normally use, but with introduction of the simplified joint stock company, it is, I think, yet to be examined and tested. The key change, which we discussed, or I think Rafiq thoroughly discussed, the issuance of bonds or the debt instrument and sukuk for the limited liability company. That has not been the case previously for limited liability companies. The issuance or this new mechanism will have to be, again, with the CMA provisions and laws and regulation. Shareholders also need to agree on that, on the articles of association. And the new change meant is to provide LLC with a greater flexibility with the shareholders to pledge their shares and issue the sukuk or any other debt instrument. The new companies law, the second point is the new company law has removed the restriction on the single shareholder company owning another single shareholder. Practically, there has been some issues, and now we would expect that in the practice that will help, especially with the holdco, hold companies and group companies where they own different structures. Tag along and drag along is also available for the LLC companies, and shareholders can agree on that. It's referred in Article 181. Statutory reserve can be agreed in the article of association. The current law require shareholders to reserve 30% in a statutory reserve, but currently the law is got greater flexibility on this. If you move to the next slide, please. So another key change we highlight here is the losses of share capitals in the joint stock companies and limited liability company. The current law, Article 181, which is quite popular for a lot of companies, that when share capital losses reaches 50% or more, shareholders are required to meet from the date, within 90 days from knowing and resolve a resolution to support the company and publish it in the official Gazette or Ministry of Commerce website. Or if nothing happens, the company will be deemed dissolved by the force of law if no action is taken. Again, that is quite problematic in practice, because it wasn't easy to the Minister of Commerce to confirm if a company is dissolved by the force of law. Now, the new law refers to a meeting within 60 days. If the shareholders are aware or become aware of the losses, they should meet within 60 days from knowing about the losses and agree whether to continue the company or take any immediate action to rectify the situation or liquidate the company. The law didn't refer to a resolution being published on the official Gazette or on Ministry of Commerce website. But again, we think this is an interesting point, because it's decreased the time from 90 days to 60 days, and there's no reference to the publication. Next slide, please. The family charters and partnership shareholders agreement is also a key changes, and we would expect in private practice to see more of these in as soon as the law becomes effective and enforced. Article law, if the new companies law regulate the shareholders agreement and family charters, the shareholders agreement are common in joint ventures and complex projects. The shareholders have the right to agree on shareholders agreement or family charters during or after the incorporation process, which is the idea is to organize the relationship between the shareholders and the family members between themselves. The shareholders agreement and family business charter are considered binding and shall form a part of the company's article of association and bylaws, as long as they don't violate the law and the articles and the bylaws. The current practice is the ministry have issued guidance for guidance purposes, for governance manual for family businesses to follow as guidance. But now with the new change in the new companies law, the charter can become effective, and different company may want to have different agreements in their provisions of the articles. Currently, what we see in practice, a lot of inquiries whether family can insert different provisions and articles in the articles of association that is not in line with the Ministry of Commerce template. There has always been pushback from the ministry due to the lack of certainty in this area of law. But now, and a separate or a independent agreement was used to govern the relation. But now with the new law, we would see a lot of activity on that, and we would think there will be some innovative arrangements between family members and shareholders. It has been a quite difficult position historically, because such agreements have not been fully recognized by the courts, or the court practice, let's say, have not been consistent in interpreting the shareholders agreement and family charters. But with the new law, the agreements regulating the relationship should be an agreement that can be taken by the court and enforced accordingly. This is an interesting development of this area of law, particularly important for stakeholders with the complex shareholders arrangement in Saudi Arabia, who rely on bespoke contractual arrangement provided for their shareholders agreement. Next slide, please. The introduction of not-for-profit companies is another significant changes and will enhance the third sector. In the past, not-for-profit company was kind of a gray area, but now with introduction of law of this in the law will be huge support for, we would think, for charitables and building society to consider public and private, whether public or private companies for the not-for-profit companies. Not-for-profit can be either public or private, and it can be, if it's private, can be converted into public. There is some certain incentives and exemption. In particular, there will be tax exemptions. The dividends and the profits must be brought back to the community. The Center for Non-Profit Sector will confirm how this will be regulated in practice. The Article of Association also would give more details of how dividends can be distributed. The restriction on not-for-profit company, they can't go for public, and they can't go for IPO. I think with that, I will hand over to my colleague, Ambreen, to talk about the director's accountability and liability.
Thank you, Omar. I'll start with summarizing the changes related to directors' accountability and liability under the new companies law. And these are covered under Article 26 to 32.
Can we move to the next slide? I think they're on the next slide. Yeah.
The directors have a certain level of accountability as their decisions impact the company and the shareholders' interest. So under the existing company law, the standard and liability varies depending on the type of company. Further, those liabilities have not been further defined anywhere in the existing company law. So for example, for joint stock companies, directors are liable for the mismanagement or for wrongful act. However, for unlimited liability companies, they are liable for omission or negligence. In case of limited liability companies, they are liable for wrongs committed in performance of the duties. So moving on to the new company law, there are two key changes related to directors' accountability. The new company law extensively redefines the accountability standards and imposes an express duty of care and loyalty on the board members and managers of all companies. Unlike the current companies law provisions, the new provisions are standard, and those are applicable to all types of companies. There's no variation in the standard. So the new company law, in addition to imposing an express duty of care and loyalty, which is a fiduciary duty, it also explains what needs to be done to meet that duty. For the purpose of meeting this standard of care, a director is expected to exert extensive efforts to serve the interests of the company. It is also required, the directors are also required to act independently when adopting any resolution. They need to discharge the duties with reasonable care and due diligence, and they need to avoid conflict of interest and not make any secret profit. The purpose of these provisions is to enhance the performance of the corporates and assure the continued success. Also, these express obligations reflect similar requirements under the Capital Market Authority's corporate governance regulations. These regulations apply only to listed companies. So with this express duty of care being imposed to all the companies under the new companies law, the duty of care will now apply to all the companies, whether they are listed or not listed. Moving on to the liability of the directors, it is important to note that the directors will now be liable, for even mistakes, negligence, faults, and that cause damage to the company, or if they fail to meet their obligations under the company's law. And the liability will be owed not only to the company, partners, shareholders, but also to third parties for any damages sustained by them or by the company. However, it is essential to note that the term third parties is not defined. So what happens if the directors does not meet their obligations? A company can institute a liability suit against the directors for damages caused to the company. And in the event if the company fails to file a suit, shareholders holding at least 5% or more of the company's capital can file a lawsuit. It's usually called a derivative action. And the board members' liability can be either joint or personal, depending on the resolution that has been passed for the respective decision that caused the damage. We also note that there are different protections available to the directors, as now the duties are very clear. There is a deeming provision under the new law. So when the conditions under the deeming provisions are met, the directors are presumed to have met their responsibility. So these are the conditions. If the director has no personal interest in the subject matter, if the director is aware of the matter to an appropriate extent, and if the director is completely and rationally convinced that the decision would serve the interest of the company. Once these conditions are met, the burden shifts on the plaintiff to prove otherwise. In addition to this, a company can also arrange an insurance coverage for its managers and its directors. So as discussed earlier, that this duty of care includes a requirement to exert extensive efforts to serve the interests of the company. Next slide, please. Sorry. It requires the directors to exert extensive efforts to serve the interests of the company. So a director cannot be a silent member, and they need the board needs to actively pursue all actions that meet the company's interest. The directors should not support the interest of a particular group of shareholders or be inactive in the decision-making process. The company's law also goes on to state what is the dissenting member's liability. A dissenting member will not be liable provided the member has explicitly expressed their dissent in the minutes of the meeting. Also, failure to attend a meeting is not an excuse unless you prove that you were unaware of the resolution or you were not able to object. So in the normal circumstances, it would not be easy to prove this because directors usually get the resolutions and the material for the meeting. So upon our review of these provisions, we have the following observations. As the director is required to act in the corporation's best interest, will the director breach a duty if they prefer the interest of a particular shareholder or a group of shareholders? So often the interests of the shareholders and the stakeholders coincide, but there could be a situation where those interests are not aligned. So what will happen if the director cast his vote to favor the shareholders' interest? We conclude that it is essential to be clear that the directors owe their duty to the corporation, not to the stakeholders, and that the reasonable expectation of stakeholders would be that the directors simply act in the corporation's best interest and not prefer shareholders' interest. Um, we expect that this gap will be filled in the new companies law, or maybe through an this gap will be filled by the implementing regulations or by the case law. I would also like to point out that the word third party, which has been used in terms of liability, has not been defined. So it needs to be seen whether it would cover parties like creditors, suppliers of a company, if the director's decision has an impact on the company's business. So the key takeaway related to this director's duty and loyalty is that in comparison to the old law, this law clarifies the responsibility that the directors owe to the company, and they are supposed to observe and adhere to the decision making throughout the decision making process to guarantee that the company's interest is always prioritized. Thank you for this, and this concludes our presentation, and I'll open the floor for questions.
Thanks, Samreen. Can we go to the next slide just so we get... there were a couple of questions, Omar, I think for you mainly. You want to respond to those?
Yeah, sure. There's one question about the registration, the process of registration of the shareholders agreement. That's yet to be confirmed with the Ministry of Commerce. We have no guidance on that yet, but our expectation is it's going to be either like the Articles of Association, online submission with little input from the ministry. In other words, they won't comment on the content itself, but they will just make sure that it's submitted from the right applicant, and the applicant has the authority, without going into details of the agreement itself. They will leave that to the shareholders, and if in case of dispute, they will refer this to the competent authority, whether it's a court or arbitration. So that's yet to be confirmed, and we have inquired in the past before the law, and we understand that further clarification will be provided. The second question about the difference between public and closed registered company, there is still more compliance requirement for a publicly traded company. In particular, CMA regulation will need to be applicable, whereas the private or closed registered company doesn't have to confirm and have the governance structure as per the by the CMA. Publicly traded company, they have to have certain level of governance, whereas closed registered company don't have to unless they go in for the main market, or for the market in particular. I hope this answers both the questions.
Yeah, if there are any other questions, you can put it in the chat or raise your hand, and we can take those questions. Anything else from anyone? There are a couple of other questions come up, I think. For the SME environment, again, Omar or Chris, would you like to take that more on the SME requirement? And then presumably shareholders agreements will still be subject to compliance with Sharia principles. It's a good question, Nasir. So maybe Omar, I think both are for you again.
Well, sure. I mean, the first question about SMEs, we certainly think this will help the environment for SMEs, because there has been the simplified joint company is meant for SMEs and venture capital companies, because fund can be received with restriction on management, and that was the case in the past.
If I can add one point on that, Omar,
sure.
Sorry to interrupt, but I think one of the key things on the venture capital and SME side will probably be the ability to raise capital. So if you look at a life cycle of a venture capital structure, you'd have a series A where the family and friends kind of invest. Then you've got a series B where you've got angel investors who come in. Then you probably have a series C, or you have investment bank, and then you'll have probably a public offering. So this structure allows you to have these multiple classes of shares, which kind of on the capital raising side would be excellent. So I think that's one. Two, the management I think can be very centralized, and you don't need to have an elaborate board of directors, and I think that's a major change. The third point that Chris raised about how in-kind capital could be contributed up to 50% without fair market valuations. So if you're bringing in, let's say, intellectual property, you're bringing in some innovative technology where even valuations can be quite difficult. I think that's another thing that can come in. Sweat equity against services, so I think it brings for that. Chris, do you want to add something to that?
I was going to mention the sweat equity, Rafiq, actually. Yeah.
Yeah.
That's a obviously significant enabler of establishing a small an SME.
Yeah, great. Nasir, on your point, I think from a Sharia perspective, I think that's a really good question, especially with family charters. So if there was, Omar, if the distribution goes against Sharia, I mean, what would what type of approach would the courts take and authorities take?
Well, interesting. Yeah, that's a question that we have raised as soon as we saw the law out. We don't have any visibility yet. And again, that's subject to how the ministry will want to play the role here. But we think, because the question we asked, whether family charters can agree on different distribution or inheritance of shares between family members, that is not 100% in compliant with the Sharia principles. That wasn't clarified to us, and we are keeping an eye on this area in particular, because different companies would, different family members would have different structures. Same goes for the shareholders agreement, where certain aspects might not be 100% compliant with the Sharia, but if it goes to the court, then we would think the court will take the Sharia position. But then again, there is thus also the introduction of alternative dispute resolution. Arbitration in particular should give flexibility on agreeing on something between the parties that's not 100% in compliant with the local regulations. It is yet to be tested. I would say it's yet to be tested in the practice.
There's a question around from Isa around audit committees under the new companies law. Yeah, to be honest, we've not addressed the audit question in this particular presentation, and maybe that's something that we can come back to you on, unless Omar, Chris, you all would like to add something.
Thanks, Rafiq. I was just looking for the section, but there is a provision that for directors to or for a board to delegate some of its functions to a committee. But I think there's not a lot of detail there, but there is a provision for board committees, but not much detail.
Okay.
Certainly nothing specific to audit committees.
And I think the flexibility is there in Article 21 in terms of oversight, and which allows the memorandum to set out those audit committees. So it's probably not something that's mandatory, but possibly something that could be included. Any other questions from anyone? All right. I think, look, we're happy to take questions, even, if you'd like to send us an email. I don't know, are our emails on the Marwa? Have you put those up on the screen or something? Yeah, maybe, yeah, that would be helpful. Oh, that's just the generic one. But you'll find us on the Tamimi website, all four of us, and we're happy to take any questions. We'll probably have a follow-up presentation also when the regulations come out and when it comes into effect maybe next year. So stay tuned for that. And if there's anything we can do to help, and discuss on an ad hoc basis, we're happy to do that as well. So unless Chris, Omar, Amreen, you'd like to add something, maybe we can close the session.
Thank you so much. I have nothing to add here. Thank you.
Nothing to add, Rafiq. Thank you
Same.
everyone for attending.
Thank you all. Thank you all for attending. Thank you very much.
Thank you very much. Thank you, everyone.